Have you ever witnessed a person recognize in real time that they committed the most disastrous error of their existence? Not in retrospect, not reflecting back decades later with sorrow, but in the precise instant when the results become inescapable and permanent. I have observed this occur in legal chambers more often than I can recall, but yesterday felt different because the epiphany did not arrive during a verdict. It did not happen during an arrest. It occurred during sentencing. After every detail was already finalized, after every chance to cooperate had vanished, after the door for a plea bargain had shut, the accused stood there, hearing the magistrate calculate the figures, and suddenly grasped that this was happening, that he was headed to prison for decades. And in that second of hopeless insight, he collapsed. The sentencing procedure had been moving routinely for nearly 40 minutes. The magistrate had examined the pre-sentence report. She had heard from the government regarding the magnitude of the scam, the count of victims, the total of damages. She had listened to the defense counsel lobby for a penalty at the bottom of the spectrum, standard protocol. Everything was sticking to the anticipated script. The accused had been waiting at the defense bench with his lawyer, palms joined in front of him, eyeing the magistrate, expecting the unavoidable. Then, the magistrate started reviewing the sentencing criteria. She evaluated the type and details of the crime, multiple counts of embezzlement over various years, calculated dishonesty. She spoke about the background and traits of the accused. No previous legal record, but also no sincere admission of guilt. She discussed the requirement for the penalty to mirror the gravity of the crime, tens of millions in damages, corporate confidence shattered. She cited the necessity to provide equitable retribution for the crime, the necessity to ensure sufficient deterrence, the necessity to safeguard the public. With every factor, you could observe the accused's demeanor shift. His frame began to droop. His respiration grew rapid. By the point the magistrate arrived at the tally of the guideline bracket, he was noticeably shaking. The magistrate declared that based on the aggregate criminal behavior, the suggested guideline bracket was 30 to 37 months. But, she went on, she remarked that given the aggravating elements in this matter, she was weighing a penalty above the bracket, notably above. That is when the energy changed. The magistrate stated she was considering a term in the neighborhood of 20 years. 20 years in government custody for embezzlement. The accused's legs gave way slightly. His counsel gripped his limb to support him. The magistrate kept talking. She remarked that the accused had exhibited no regret throughout the proceedings, that he had been untruthful on the stand, that he had tried to ruin proof when the probe started, that his behavior revealed a degree of criminal purpose that justified. Yet the accused was no longer paying attention. He faced his lawyer and muttered words. The lawyer tilted his head, replied with a whisper. The prisoner's volume became higher, high enough that folks in the gallery could catch fragments. "Inform her. I can assist. I possess data." The magistrate halted. She had been reciting from her typed penalty declaration, but she ceased, glanced upward. The convict was now entirely focused on his counsel, signaling wildly. The counsel was attempting to soothe him, attempting to force him to look ahead, but the convict yanked back. He pivoted toward the bench, and he shrieked. No speech initially, just a primal noise of hopelessness. Then phrases began emerging, piercing, panicked. "I will reveal all of it now. I will collaborate. I beg. I have identities. I hold records. Only grant me an opening." The magistrate lifted her palm. "Sir, you must settle yourself." The accused disregarded her. He continued speaking, yelling. "I can provide the bookkeeper, the counselor who organized it, the finance chiefs who understood all. Only, please, not 22 years. I will disclose everything." His lawyer was tugging on his sleeve, seeking to make him quit, but the prisoner was past hearing. He had shifted from poised to entirely disintegrated in the space of 30 seconds. The magistrate slammed her mallet once, firmly. The noise reverberated across the chamber. Mr. Miller. The state attorney was tactful in her reply. She remarked the government constantly appreciates assistance, but she mentioned that the prisoner had been granted several chances across 24 months, that he had turned down every deal, that he had vigorously hampered the inquiry, and that any assistance today would be judged against his extended record of refusal to help. Interpretation? Not enough, far too tardy. Allow me to clarify what just occurred through a judicial lens. The accused believed he could win the matter in court. He assumed the panel would exonerate him, or at most find guilt on certain charges but not others. He wagered that the proof was not powerful enough. He failed that wager. Next, he assumed that even if found guilty, he would receive a fairly minor penalty, perhaps the bottom of the spectrum, perhaps even under the spectrum. He wagered that his absence of legal priors and the peaceful character of the offenses would serve his benefit. He failed that wager as well. And now meeting 22 years, he at last grasped he ought to have assisted from the start. Yet at this stage, his assistance holds virtually no merit. This is why. When a person assists early during a probe, they can supply data that aids in constructing the matter. They can name other suspects, describe how rackets functioned, direct agents toward proof they might not have discovered otherwise. That type of assistance is precious. The state compensates it with significant penalty decreases. But when a person stalls until after they have been found guilty and penalized, their assistance is worth far less. The matter has already been established. The accused has already been declared guilty. There is no litigation to aid with, no settlement deal to bargain. Any intelligence the prisoner offers now will be seen with deep doubt, because it originates from someone seeking to cut their term after the outcome. Furthermore, prisoners who assist late surrender trust. If you wasted 2 years fibbing and resisting, why would lawyers trust you are abruptly being honest today? You have shown that you will state whatever aids your agenda. How could anyone believe that the data you are supplying is correct and not simply more deceit intended to trick the process? This trust issue makes tardy assistance hard for lawyers to utilize, even if the data is precious. There is also a functional hurdle. Government penalizing occurs rapidly. Once a magistrate declares a penalty, it is fixed unless there are distinct legal bases for review. The accused cannot simply offer to assist and anticipate the magistrate to lower the penalty. There are protocols that must be observed. The prisoner would have to supply massive. That 19-year gap represents the cost of his choices, and shouting, "I will help," during the heart of a penalty proceeding cannot reverse those choices. Let me speak to what you may be considering. Is it equitable that the framework punishes individuals for using their right to a hearing? Should assistance be mandatory to obtain a fair penalty? These are valid inquiries. The legal framework does establish a motivation layout that prizes early assistance and punishes going to court. Some claim this is forceful, that it pushes blameless individuals to admit guilt. Others claim it is vital, that intricate matters cannot be tried without internal assistance, and that providing lessened penalties for assistance is the sole method to break down illegal groups. I am not here to settle that argument. I am here to clarify how the framework truly operates. And how it operates is this. If you are culpable, and you realize you are culpable, assistance is nearly always the superior path. Not because it is just or unjust, but because it is fact. Prisoners who assist early receive massive penalty cuts. Prisoners who resist and fail receive peak penalties. The accused yesterday picked the second route. He wagered that he could triumph at court, or at least obtain a minor penalty. He failed, and now he must endure the results of that wager for the coming 22 years. One further detail worth mentioning. The magistrate's manner during this dialogue was enlightening. She was not furious, she was not spiteful, she was objective. She clarified softly and precisely that the accused had lost his window to assist, that his final hour panic did not alter the math, that actions have results. This is how seasoned magistrates manage these events. They do not boast, they do not preach unnecessarily, they merely express the truth. You possessed chances, you did not seize them, the period has lapsed. I have been contemplating this matter since yesterday. Regarding the second the prisoner shrieked, "I will disclose all of it now," because that second captures something essential about the human spirit. We persuade ourselves that we possess more duration than we truly do. We believe we can stall, observe how events unfold, keep our paths open. And then abruptly, the gate shuts, the chance is lost, and we are left yelling into the emptiness, pitching things that nobody desires anymore because we delayed too long to pitch them. In legal matters, this pattern occurs repeatedly. Accused individuals delay assisting. They delay admitting liability. They delay speaking the truth. They believe they can schedule it perfectly, assist only if mandatory,